The one thing that must really be clear is that this is a trust matter, and the ones bringing the claim against the trustees have the lowest of the lowest of the lowest position within the trust relationship. So bear that in mind throughout this whole thing. You know, the current events that are currently going on right now either brings people together or divides them. Whatever format you think you're going to use to fix your issue at a time like this, just know that the one that gave it to you has worked about 20 steps ahead of you to shut it down. Limited formal intellectual education that people use. And one of them was taken to the Supreme Court of the United States by way of some equitable relief. It was case 21A15. This is the official Supreme Court of the United States website. You can search cases. Here it is. Here's the docket. Remember, we're not saying anything is wrong. We're not saying anything is right. Case number. Case title. By Ryan Klaassen et al. Amongst others, meaning there was more than one plaintiff. Versus Trustees of Indiana University. The date, August 6, 2021. The lower court, United States Courts of Appeal, 7th Circuit. Bill makes the final decision and determination of judicial matters. Case was opened on August 6th. Another thing was put in on August 10th. Main document. Alright, let's see. Zoom it in. The Supreme Court of the United States. Emergency application for writ of injunction for inequitable relief. Requested by August 13, 2021. Okay, within a week or so. To a specific acting judge. An associate acting, who is an associate acting judge, the Supreme Court. Questions presented. Whether a heightened scrutiny applies to Indiana University's mandate that IU students take good old CVD in violation of their constitutional rights to bodily integrity and autonomy and medical treatment choice, so that IU must prove that its mandate is justified, which the court below erroneously failed to do so. So there's a previous proceeding regarding this going on somewhere. Whether IU failed to prove that mandate is justified under heightened scrutiny. Keep in mind this is 39 pages and we're not going to go through all this. You have access to this, so read it. Talks about the FDA emergency use, modern medicine ethics, the CDC recommendation, Indiana state requirement, Indiana Public University, state, age group, the risks. Alright. So our moralistic stuff. The way you're viewing this engagement is not the same way people that you're dealing with are viewing it. It is moving, and it makes sense for people to want to speak up and just be who they are. It's their inherent freedom to enforce the things that's been written down that substantiates the same. So now I'm trying to do a certiorari, which is basically an appeal. Then it lists a bunch of case laws. Alright, cool. Case laws, after case laws, after case laws, after case laws. Said it, and I'm going to keep saying it. You can list all of the case laws that you want. If you're not putting it in properly, and if these case laws are not appellate decisions, most importantly, you're not looking at the details of how the conclusion within these case laws came about. You're just playing with somebody else's property. Just because you list case laws after case laws does not guarantee that your point will be proven or substantiated. It makes sense what's in the case laws, but do they have to look at it and really put it into consideration? Depends on how you bring it in. Oh, look at this. 14th Amendment is one of their main tools that they're using when it comes to the Constitution. Of all the substantive right within that Bill of Rights, the one thing that you're dealing with is the 14th Amendment. They're requesting a writ of injunction by Friday, August 13th. Student challenged the IU's mandate requiring students to take the CVD. Despite their objections, students' refusal is based on legitimate concerns, absolutely, including underlying medical conditions, having natural antibodies, yep, and the risks associated with the good old jab. All students or adults are entitled to make their own medical treatment decisions and have a constitutional right to bodily integrity, autonomy, and of medical treatment choice in the context of the jab mandate. Whenever an acting judge reads this, the moment they see this right here, just this sentence, they don't even have to read anything else beyond this. This alone speaks to the fact that whoever the group of brave and very intelligent men and women who came together and constructed this equitable relief petition, it lets the acting judge know that you obviously don't get it. If you're a student of a university or college, you are deemed their property. No different, because universities and college, let's just look at the basics here. This is nothing spurious, this is nothing far-fetched, this is something well known. Universities and colleges are considered institutions, learning institutions. The structure of universities and colleges, high schools, middle schools, grade schools, the blueprint of the buildings are designed by the same people who design prisons and jails. Travel past a college, a middle school, and look at the way it's structured. Look at the angles, look at the function of the bricks. And then travel past a prison or jail, and you will see no difference. And just as inmates, prisoners, detainees are considered properties of whatever that incarceration entity is, state, county, federal level, so is students to universities and colleges. So if you're bringing in any grievance under the capacity of as a student, you are deemed to not have a standing or capacity because you are their property. Mandates of entities like universities and colleges and other types of entities are directed towards their members, their properties, their students. They're called mandates for a reason. It's mandatory for the property of someone to engage in certain activities. If you don't want to be their property, then don't engage in contract with them. And even if you do want to bring that up, at least invoke something regarding other aspect of the Bill of Rights and not the 14th Amendment. The 14th Amendment was never properly ratified as required by that same 1789-1791 United States Constitution. So it's not even law. It's not positive law. It's not enforceable. You really want to enforce any inherent right that has weight to it, stick with the first 10th Amendment. So this right here, if you're saying you're an adult and you're saying you're entitled to make your own medical treatment decisions, you do know they don't consider you an adult. You consider yourself an adult because you went through high school, you've got your bachelor's degree in university, you're studying your master's degree, or you've done something with your life and you've gotten someone to accredit some attribute to you based on what's written on a piece of paper to say, hey, you're qualified to do this because you spent 46 years of your life dedicated to someone else's establishment. You've dedicated 46 years of your life to get a job, to be an employee, to be someone else's tool, to get compensated anywhere from 40K to 150K, just so you can accumulate a student loan that's about 200,000. You make anywhere from 40,000, let's just say an average $80,000 a year job. Very fortunate, right? But you have a student loan that's $150,000. Stop and think about that. Student loan of $150,000 for an $80,000 a year job. That alone by itself substantiates the fact that you're not an adult. You're not handling your own affairs. That contract that you have out there that makes you liable and is still lingering, demonstrate you don't have the ability to contract properly. Besides the fact that the moment that you are considered a student of any university, you are their property. And no evidence exists that you are competent to make these claims on record, although immense amount of presumptions exist otherwise. And it is not their liability or obligation to disclose that to you. If you're coming in and saying you're a student of a university, and because of that, you're saying you have a constitutionally secure right based on the 14th Amendment, which is not even ratified to be a law. Do you see all the odds that are automatically stacked against you just by reading the first page of the introduction of your claims, and you're bringing this into equity? Injunctions are equitable relief. You want an equitable relief and you barely even don't have a stand-in? You're a volunteer. Maxims of Equity let you know that equity doesn't aid a volunteer. So all these things are legitimate. They make sense. But you're standing in capacity right from the start is moot. IU, however, is treating its students as children who cannot be trusted to make mature decisions, and has substituted itself for both the student and her attendant physicians, mandating a choice which is the student's to make based on her physician's advice. You said it. You absolutely said it. Now you've diverted your own cause of action to just merely complaining. When you're in equity, you don't bring complaints. You don't complain. At this point, whoever the law clerk or the attorney that handles paperwork for this acting judge, they're just rolling their eyes while looking at this. Like, okay, there we go. Someone just want to whine and cry about things. First problem. You're using the 14th Amendment. You could have at least brought other claims like your First Amendment, right? That has so many different clauses to it. Separation of powers, right of association, religious rights, so much more. You could have brought in the 4th, 5th, 6th, 8th Amendment, cruel and unusual punishment. Someone is forcing you to put something in you that you know, based on all these evidence, that you're bringing it, that it is bad for you, then would you not consider that cruel and unusual punishment, especially if you're invoking equity? If anything, if you want to do an injunction on anything, your main purpose should be based on cruel and unusual punishment. That is more urgent. That is more life-threatening. But you didn't. You invoked 14th Amendment. To make it worse, you even admitted your property. So automatically you admitted your property to an entity that's making its own private laws. And they can't step in. It's a private contract that you've entered into as a student. That's part of the terms and conditions. Now you're not even bringing up hidden terms and conditions, and you're going into how someone is treating you like a child. So that means this is just how you feel. And everything else that you're bringing in is just a guise of intellect, or guise that something is right, or that you have a right. Yet, the supposition of law you're bringing in is 14th Amendment, which is not even lawfully ratified. This is what I mean by this thing that's going on in the current events. Is either going to be something that's going to compel people to really come together, or be divided for good. Because there are people who are under formal education and have invested so much of their lives in it that they are not looking outside the box. They're not picking up other things to just study and read, to do some self-reflection, to go into Library of Congress archives and read things, to go into your state archives and read things, to read treaties, to sit down and really try to comprehend what these constitutionally secure rights really are. Because if these people who constructed the suit, this case number 21A15, if they really knew what they were doing, had they really sat down and read the Constitution, the moment they reached that First Amendment, that 9th and 10th Amendment that says all powers that are not given to the United States are reserved to the people, that alone, that 9th or 10th Amendment, constitutes everything else. And you're not bringing any of that up, and you just go through the First Amendment, second one, third one, fourth, fifth, sixth, seventh, eighth, ninth, 10, 11, 12, 13, and you are claiming 14th Amendment. That is an issue right there. And you're speaking about students' choice. You don't have a choice. If you're a property, you don't have a choice if you're not bringing any law in that substantiates you having any rights. So automatically, if there is no law that you're bringing in, and you're a property of someone who's saying you're in my house, you got to do what I say you ought to do. You can bring all this in all you want, considering it's not really being introduced into evidence properly. And evidence is the only way any judicial actor can really admit anything and put it into consideration for the final conclusion and the finding of fact. You see all the flaws going on here? Just in the introduction alone. The district court opinion, an order denying preliminary injunction relief to student is yet unreported, but at appeals 8A preliminary injunction, so this is the previous bill, its denial, meaning they've been denied previously, of an injunction pending appeal is unreported. Seventh Circuit denial of an injunction pending appeal is unreported, meaning they've been trying and trying and trying. It's not that they're wrong, but how they're coming in is not giving them any standing. First basic thing before you begin to make a claim upon which relief can be granted. You're over here making equitable claims, demanding equitable relief. Of course it's going to be denied. Constitutional and statutory provisions involved. This case involves the 14th Amendment to the U.S. Constitution. It speaks about the mandate. It's like the executive order on a state level. There's a video that was done before on this page regarding a letter by the Attorney General of the Illinois state. It basically says, look, the Illinois Constitution, now this is Indiana. I'm sure there's an equivalent version in Indiana, which is right next to Illinois. In Illinois, the Attorney General said, look, executive orders doesn't give any governor any power to create any new law. And executive orders only apply to executive departments and its agencies. In other words, it doesn't apply to the public at large. It doesn't apply to the private man or the everyday man or woman unless you allow them to. So guess what? If Indiana University passes a mandate, then it applies to all its agencies and all its students and employees. And if you want to claim otherwise, bring in the law. No law has been brought into this case in any way, shape, or form. Most of these are morally correct. Most of these things make sense. But the basis of it is dead. It doesn't take a genius to realize that. Your reference cases 21A15. Now I've just shown you how you can find out about it to the official United States Supreme Court. But after sitting down, reading all these pages after pages after pages, one thing I realized was no law was really brought into this thing, and no evidence was brought in to substantiate any of the claims being made. Instead, what was done was they were just pointed at some private law and did not approach it in a manner that says, hey, this doesn't apply in any way, and it's not enforceable, and that we don't qualify for it. And guess what happened? They required the injunctive relief to be given to them by August the 13th. And on August 13th, do you know what happened? This happened. Application 21A15 denied by Justice Barrett. Lesson learned here is, if you're going to dabble in anything, know what it is you're doing before you start. Or else what you will be doing is you'll be creating a stockpile of ammunition that will be used against others because of your haste and your lack of knowledge.